I would first like to welcome all of you to our webinar titled, Getting Back to Basics. The presentation will last about an hour with a question and answer period at the conclusion. If you have any questions throughout the webinar, please utilize the chat feature box on the right-hand side of your screen. Without further ado, I would like to introduce our presenter, Vice President of Employer's Choice Online, Cody Farzad.
Thank you, April. That's April Glaze, and she actually is the Director of Operations for Compliance Training Group. And I had enlisted her to come on and just kind of review the webinar with me and introduce me because she's new to the company, and she's going to be doing these for Compliance Training Group as well. So like April had mentioned, the presentation will last about an hour with a question and answer period at the end. If anyone is having problems or issues viewing the presentation or hearing my voice, if you could just utilize the chat feature and just put down your name and what your issue is so we could work through that. But I'd like to welcome everybody to the webinar titled Getting Back to Basics. This is our first webinar of the year. We like to do these quarterly, so we're a little bit behind. So we'll probably be hosting another one here in the next couple of months. As all of our webinars, they are hosted on our website, so if anyone has to leave the presentation early, both the audio and video will be uploaded to our website approximately a week after the presentation. And I always encourage clients, consumers, competitors, employers, anybody to attend these webinars. They're very, very informative, they're complimentary, and it's just a value-added service that we offer to anyone that wants to listen in. We also encourage you to email topics that you would like in future webinars. The best way that we could get this completed and draw more interest is by doing subjects and conducting webinars based on our clients or employers or consumers' wants. So let us know what kind of topics you would like us to cover, and we would have no problem crafting a presentation and hosting it later on in the year. So without further ado, we could go ahead and get started with the webinar, and again, it's Getting Back to Basics. During the presentation, if anyone has any kind of questions at all, please don't hesitate to utilize the chat feature or send an email to me, and we'll go ahead and cover that at the end. This is me, Vice President of Employer's Choice Online, and my main responsibilities is to promote best practices and industry standards with regards to employment background checks, as well as I like to consider myself an in-house expert on the Fair Credit Reporting Act, and the FCRA is the federal law that governs what background screening companies can and can't report on an employment background check. And then I also like to educate clients and consumers and employers on states that have their own laws regulating consumer reporting agencies, or CRAs. Employer's Choice Online is a CRA, and the definition of CRA is any company that procures employment background checks for employers so that they can make an employment decision. This is a disclaimer. Just the information provided in this presentation is for informational purposes only and not for the purpose of providing legal advice, and should not be relied upon as legal advice. As the labor and employment law is a dynamic field, often with varying results from state to state, you should contact your attorney to obtain advice with respect to any particular issue or problem. What you guys will learn today. We'll cover the FCRA, specifically kind of the history of it, its inception, and why it's put in place. We'll also go over why companies should have a background screening policy if they're electing to do employment background checks. That's very important. We'll go over disclosures and authorization forms. These are the forms that applicants must complete authorizing the employer to conduct a background check on them. We'll also go over notices the applicants must receive once they complete the disclosure form, just specifically stating what their rights are. We'll go over county-level criminal searches versus instant nationwide database searches. We'll go over the difference between federal criminal records as opposed to state-level felony and misdemeanor criminal records. We'll discuss employment and education verification and employment and education investigation. We'll go over employment drug screening, talk about pros and cons of social media. That's in there because that's a very hot topic right now with regards to our industry. And then we'll close with the pre-adverse, adverse action process, and then also allow time for question and answer at the end of the presentation. Okay, so what is the Fair Credit Reporting Act? It was created in 1970 specifically to address issues regarding consumer credit. Now, when employers or consumers see consumer credit, they just assume that it's a credit report. But consumer credit is the person's credibility with regards to their personal finances, their criminal records, their driving records, their references, employment history, things like that. The purpose of the FCRA was to promote accuracy, confidentiality, and relevancy of information. So we, ensure that our reports are to the maximum possible accuracy with all confidential information being truncated and not appearing on the report. And we try the best of our ability to ensure that the information reported does belong to the person who is the subject of the report. It was amended in 1996. It was effective in September of 1997. They added a few more regulations and guidance on backgrounds. The main purpose is to regulate the use of consumer report information and other background information received about individuals from consumer reporting agencies. And consumer reporting agencies are just copying and reporting public records from various sources. No investigations are done at all with regards to employment background checks. We are just reporting public record information from various public sources, courthouses, universities, employers, credit bureaus, things like that. And like I mentioned, a credit report or a consumer credit report is not limited just to their credit. It includes all sorts of information bearing on a consumer, including public records, employment, education, driving history, etc. Why should companies have a background screening policy in place? It's very, very important, obviously, to do background screening on applicants, but more importantly, before you even implement that, a screening policy should really be put in place. The main reason is that it eliminates any claims of discriminatory treatment, i.e. race, color, gender. And what that means is, let's say that an individual is applying with the company and they are in a driving role and a driving record is conducted on them. Conversely, an accounting person is applying with the same company and a credit check was conducted on them. An employment decision was made that they weren't going to hire the accounting person because their credit wasn't up to par or didn't meet the company standards. Potentially, if a background screening policy wasn't in place, that accounting applicant could claim discrimination as to why wasn't the person that was going for the driving position had their credit ran on them. Well, obviously, the credit wasn't run on the driving position because their credit was not part of the responsibility or duties of the job. But what the background screening policy states is specifically what searches are going to be done on specific positions, and that will deter any kind of claims of discrimination. That promotes a safer workplace. Obviously, by conducting employment background checks, you're showing to your employees, you're showing to your vendors, you're showing to your clients that you're taking a proactive step in ensuring and fostering a safe workplace. Also sets parameters and matrix for disqualification of employment. For instance, any felony convictions within the last 2 years is automatically disqualified. Any bankruptcies occurring within the last 5 years could be grounds for automatic disqualification. Any driving convictions within the last 3 years for driving positions could be called for disqualification of employment. You just really want to make sure that you specifically state what's considered disqualification. You don't want to just make a blanket statement where any criminal records within the last 7 years or criminal convictions within the last 7 years would be disqualified. And actually the EEOC, the Equal Employment Opportunity Commission, just released more guidance on how employers should be handling any kind of criminal records that they receive on a background check. And they really want employers to look at 3 things. Obviously, the time that it's been since the crime has occurred. Is it related to the job that they're going for? and what have they done in the meantime. Did they complete their probation? Have they not gotten in any other trouble? And the EEOC really wants employers to sit down with applicants and go over the background check and see if the criminal record really would have an impact on their position with the company. It's also, background screening policies are put in place to comply with laws and federal contracts. A lot of our clients have been awarded contracts, and the contract is stating that background checks must be done on their employees, whether they're new hires or they've been employees for 10, 15, 20 years. There needs to be a policy in place stating that, yes, our company conducts background checks, so that if you are awarded a contract, that's already put in place. A background screening policy also outlines specific processes that will be used to perform the background check. Anything from interview to completing a disclosure and authorization form, providing an application or resume, to turnaround time to get the background check done, and then once cleared or not clear, you take it from there. Again, it minimizes exposure and liability. Let's say that you did a background check on an individual and you did a comprehensive one. However, there are cases where we don't find out everything. And let's say that employee, for instance, makes unwanted advances or sexually harasses another employee. Well, you have in place, and if that employee tries to claim negligent hiring, well, you could state that, sorry, our background screening policy states that all background checks were done on every single employee that came through our doors, including this one. And it also reduces operating costs. It really helps you save money on those individuals that will be costing your business money by training them, providing them with extra resources, and it just helps saving your overall operating costs, and especially in this economy, that's very, very important. So this is just speaking to background screening policies. 7 crucial sections of the screening policies are the purpose of the policy. Why are background checks being done on applicants? To harbor a safe workplace, mandated by law. You could say that the purpose of the policy is also to deter, criminals from working for the company. For whatever reason, you just need to state why the purpose of the policy. The scope of the policy, this will specifically state who's subjected to the background check, with the entire scope of it, what background searches are going to be done, who would be managing the process. So that's the scope of the policy. And the responsible organization is the department within the company that would be managing the entire process. Usually that's done through human resources, payroll. Usually it's done at the director of operations position. It just depends on the size of the company. So you really need to state who is the one responsible for managing the background screening process. Sensitive positions. If there are certain positions within your company that additional searches are going to be done on executives, on VPs, on managers, supervisors, specifically spell out what those sensitive positions are and what specific searches are going to be done on those individuals. Also, it should have in place what are the hiring manager's responsibilities. What the hiring manager's responsibility is to receive the background check, obviously check it for any derogatory information, and then make an employment decision. Their responsibility, too, is if they're not going to be hiring somebody based on the background check, they need to ensure that the pre-adverse and adverse action process is being followed, and we'll go over that later on in the process. Retention of records. They also want to state that records are kept, reports are kept for an undisclosed period of time, usually for as long as their tenure is with your company. Upon termination is how long you should be retaining records. That's our best advice. And the last section of the policy is the legal compliance. Specifically, background checks are being conducted to comply with such and such law. Another real important tool that employers can use and has actually helped our company is posting signs that your company conducts employment background checks. This is a very easy, simple tool that can go a long way, and obviously placing them in visible areas of your office where the applicant would be completing the employee application, in a lobby, break room, wherever you have them complete the application. There's 2 examples there of notices that we provide to our clients. So upon our client's request, we'll have no problem sending these posters, and they could laminate them if they'd like, make them larger, however they want. We could send it in a PDF, or we could mail it off to them in a nice colored copy, and both in English and in Spanish, and posting it in your lobbies. It really does deter individuals who are trying to hide something. Disclosure and authorization forms. Section 604B, subsection 2 of the FCRA in general states, before requesting an employment background report, the employer is required to provide specific disclosures to the consumer, stating that a background report will be procured to determine suitability for employment. Report will be requested from a CRA. Name and contact information of the CRA is visible, and types of information that will be provided. This is extremely important that you're utilizing a disclosure form that was provided from your background screening vendor. There is information that background screening companies need that employers are not permitted to ask before the applicant is an employee. For instance, the full date of birth. To conform with the Age Discrimination Act, employers are not allowed to know the age of the employee pre-hire if you're doing it as a pre-employment screening. However, background screening companies or CRAs need a full date of birth in order to complete the background, specifically criminal record search. Criminal records are held by a name and date of birth match only. So we need that full date of birth in order to complete the background. We're asking for that on our disclosure form. The employer isn't. So it needs to be a standalone form separate from any internal applications, notices, things that the employee must complete for the company. And it must be a standalone form, and they know, okay, now that you've completed the employee application, as part of our policy and process, we conduct background checks. Please complete this disclosure and authorization form. The background screening company must appear on the form. The applicant must know which company is doing the background in the event they need to dispute any of the information if the employer is going to be taking any adverse action. And more importantly, it needs to list any and all searches that could be done for employment purposes. Credit, motor vehicle reports, criminal records, credit worthiness, interviews with personal professional references, education verifications, employment verification, workers' comp, so on and so forth. And that's considered a boilerplate form. So any and all searches that we are allowed to conduct for our clients appear on our disclosure and authorization form. The disclosure must clearly and accurately disclose to the consumer that a consumer report including information as to their character, general reputation, personal characteristics, and mode of living may be made. This essentially would be a personal reference verification. A lot of employers, a lot of clients of ours has questions regarding this specific language. And this is not to say, I mean, we're not going out and doing field interviews or sending out surveys to the individuals that these people know. This is just basically covering a personal reference verification if an employer would like to do that. Applicant notices. So once you've provided the applicant with the disclosure and authorization form and they've completed all of the information and have given it back to the employer, it's extremely important that you give them what is called the FCRA Summary of Rights. And this explains all of their rights under the Fair Credit Reporting Act. It lists all the bureaus where we pull information from. TransUnion, Experian, things like that. It specifically states the adverse action, pre-adverse, adverse action process, and what their rights are under the Fair Credit Reporting Act. There are certain states that have specific notices as well that must be given to the applicant. In the state of California, not only is the FCRA Summary of Rights given to the applicant, but there's two other notices that must be given, and that's the California Statement of Consumer Right and the notice regarding background investigation. So essentially, there's three notices that must be given to California applicants. In New York, there is a separate New York-specific release form. So in addition to the disclosure and authorization, there's a second release form for New York residents that they must complete. And they must be also given what is called the Article 23A. And this was a law that came out about 3 years ago, in that any convictions that a New York company, or I'm sorry, that a company gets from a New York resident, they must be given this Article 23A, specifically stating what kind of crime it is, the severity of it, and what could potentially be the adverse action. And this was in response to a lot of, I guess, ex-cons in the state of New York were being discriminated against because they're criminal records. So they want to make sure that, again, just like the EEOC provided guidance within this last month, that employers are really looking at the crime, analyzing, is it going to be specific to the position they're having, and how long has it been since the crime occurred. And now I want to talk about county-level criminal searches versus instant database criminal searches. This is the one topic that we're constantly educating prospects, inquiries, consumers on. This is very, very extremely important. County-level criminal searches. All felony and misdemeanor records are held in each county nationwide. They're not held anywhere else. Anytime an individual is convicted of a felony or misdemeanor crime, it's held in the county where the crime had occurred. Like I mentioned before, records are kept by name and date of birth match only. There are other identifiers in some cases. There could be an address on file. There could be, there could be a social security number, but that's not the case in every single record. All records are kept by a name and date of birth match. And it's very, very important if you have a common name to ensure that you're providing a middle initial to your background screening company, especially in a large county. County-level criminal searches are in real time. These are hand searches conducted by licensed court researchers. We have a network of researchers in each county nationwide and licensed in the states where they must be licensed to pool these criminal records. They go to the court daily. In some remote court locations, they may go every other day. But the fact of the matter is we're utilizing a researcher to go into the courthouse and search the court records. This is really the only way to confirm if an applicant has a criminal record conviction. We recommend doing a Social Security trace on the Social Security number to ensure that you've checked in all counties where the person has resided in. So if they've currently resided in one county, that's great, but what if they just recently moved there? The Social Security trace will give you kind of a roadmap, a list of addresses where they've resided, and obviously any counties within the last 7 years should be looked in for any criminal activity. And the trace also will reveal any and all names that they've gone by as well, because of course criminal records are held by a name and date of birth match. So you want to make sure you're seeing all the names that the person's gone by within the last 7 years and which counties they've resided in. Instant nationwide criminal database searches. This is a search that a lot of competitors, a lot of large companies like to sell to employers, and they make it seem like this is a nationwide criminal search. You'll know 100% that this person is either a criminal or not. It's done instantly, and you'll get records on it. Well, fact of the matter is that the FCRA has identified 2 limitations with regards to a criminal database search. The first one is that the information is not pooled in real time. There's sometimes a 2 to 3 month lag to get records uploaded to these databases. So if an individual was convicted of assault last week in a county that, let's say, reports their cases to a nationwide database, that wouldn't be captured because the information is not uploaded in real time. It's not uploaded to these databases each day. It's almost, some databases are monthly. The second limitation is that not every single county contributes to these criminal databases. There's somewhere of over 3,300 counties nationwide. Not every single county in the U.S. reports their cases to a nationwide database. They may not have the capabilities, they may not have the infrastructure, they may not have the staff to upload these cases. For instance, in Southern California, Los Angeles County, a huge county, doesn't report their cases to a nationwide database. So if an employer is doing a nationwide database, they put in the applicant information and they get no records found, they're kind of getting a false sense of security in that, oh great, this individual doesn't have any criminal records. Well, that may not be the case, in that he actually committed or she committed the crime in a county that doesn't contribute to a database search. A lot of database searches are name match only. So if you have a very common name, you're going to get a lot of results that don't even belong to your applicant. And a lot of employers don't have the experience to read criminal records. And they're just going to go ahead and make an employment decision because they see that this person's name is coming up for this specific criminal record, and they're not factoring in, oh, well, it wasn't a date of birth match, it's a very common name. Is the record even reportable? Because a lot of records that consist in a database search are frankly outside of the reporting period. A lot of them are infractions for, let's say, speeding tickets or moving violations, stop signs, running red lights, and a lot of them don't have a date of birth attached to them. So you don't know if, in fact, those records belong to the person. So it's very, very important. A nationwide database search is good as a cursory search to see if there's anything out there. It should be done in conjunction with a county-level criminal search as well. Any hits that we get on our nationwide database search, our clients understand that it must be researched at the county of record, because the records you get from a database search is very, very limited. You need to know the sentencing information, and the only way to get that is by researching at the county level exactly what that criminal record is. Okay. And again, it gives the employer a false sense of security in that, oh great, this person doesn't have any kind of criminal records and they're clear and ready to be hired, and in which in fact that's not the case. Federal criminal records versus state-level criminal records. This is another topic that we are constantly having to educate and explain to individuals what the difference is. Federal criminal records are federal crimes. They're not felony and misdemeanor crimes. Types of federal crimes could be weapons violation charges, interstate drug crimes, embezzlement, mail wire fraud, and many other types of what's considered white-collar crimes. Federal criminal history records search directly accesses the federal crime repository for each and every federal district in the U.S. Unlike county criminal records, federal criminal records are held in each federal district court. And our system has the capability of doing a nationwide search where that it will capture information from each and every federal district court in the U.S. and the information is updated daily. So there's no lag on our federal criminal searches. But a lot of clients see our nationwide criminal federal search and just automatically assume that, oh, this is a nationwide criminal database search. And it's going to find felony and misdemeanor records at the county level, and that's not the case. It's going to query federal crimes held at each federal district court. Federal record searches will reveal certain types of white-collar crimes that would not be identified under a search at the county level. So if crimes have occurred on a military base or have occurred on federal land, those will only be held at the federal level. And these searches are really, really recommended for high-ranking positions, individuals in a financial industry, and executive positions. But I don't want anyone to get this confused that federal crimes are just like felony and misdemeanor record searches. They're completely different. State-level criminal records. This would be a search of felony and misdemeanor convictions. These cases are reported to the statewide repository by each county in the state in real time. However, keep in mind that not every single state offers a true statewide in that every single county reports their cases. Massachusetts and California are perfect examples in that where you must do county-by-county searches because they don't have a uniform statewide system where all records are sent to the state and you could do a statewide search. There are a lot of states out there that do have a good statewide search. So it would be a good idea to identify those states and see if you could just do a statewide search instead of doing county by county to ensure that you are, searching in all the counties where the person could have potentially committed their crimes. So again, please keep in mind that federal criminal records are federal crimes and state-level county criminal records are felony and misdemeanor convictions. Employment and education verification versus employment and education investigation. The way the economy is now, there's a lot of individuals that are out of work that have contacted our offices and want to find out about their employment history. And I tell them, well, if you don't know it, then basically an employer's not going to be knowing it. When background screening companies conduct employment verifications, we are just verifying employment information that the applicant has provided. Either on a resume or a job application, they provide their employment history to the employer. We get the information from the employer and we call and contact the previous employer, and we verify that information. Two main pieces of information we're able to verify almost over the phone as well. A lot of companies will verify information over the phone, is the position that they held with the company and their dates of employment. However, keep in mind that the applicant must provide this information. They don't have to provide this exact information, but they have to give us something to provide to the employer. Because the employer will either say, yes, that's correct, or no, this is what their title was. This is what their employment dates were. Wage earned. In most cases, companies will verify what the person had made with a signed release form. So you're getting the signed disclosure form, providing it to the background screening company. We contact the employer and they state, we'll have no problem giving you that information. However, you must submit your request via fax, email with the disclosure form. Excuse me. So we'll send the disclosure form along with our verification form, and they'll verify the wage earned. Also, for reason for leaving. A lot of times they will verify their reason for leaving if you are able to send them a signed release form. Education verification. Verifying any applicant's previous educational experience. There was a thing that just happened in the news with the CEO of Yahoo claimed that he had received his degree in computer technology. However, the fact of the matter was he actually received his degree in accounting. If a simple education verification was conducted, they would have conducted the school, verified that he did receive a degree, but it was in accounting and not in computer technology. I believe they've asked him to resign, and it's a big thing in the news right now. So just like employment verifications, we can verify anyone's previous education, anywhere from enrollment in high school all the way up to, receiving a PhD. There's a very large company, a third-party company that handles these verifications, so they're done almost instantaneously. However, there are smaller schools that it's still handled at the school level through the registrar, where we'll call them and attempt to verify the information. Just like with employers, they need to see a signed release form to release any of the information. But the information we are able to verify is if they received a degree or diploma earned. If it's just enrollment, we could then verify those enrollment dates. Usually we're able to get their major course of study, but a signed release form is required. And speaking to applicants who call us and want to investigate their history, there's absolutely no way of investigating an applicant's previous employment or educational history. If they're not providing the information to you, there's really no way of getting that. A lot of employers think they could pull their credit and look at previous employers who inquired about their credit, which you can, but what if they've been employed at places that didn't even pull their credit report? So what I do is I ask consumers, if you don't know your employment history or employment dates, go down to your local Social Security Administration office and try to pull your records based on W-2 forms that you have completed. But keep in mind that when we do employment and education verifications, we are just verifying what the applicants are providing. Employment drug screening. We also do drug testing nationwide. It's very, very seamless, very, very easy process, and something that employers really should implement. Statistics regarding employee substance abuse, 10 to 20% of workplace accidents are related to drug abuse, and employees who have used drugs are 2.2 times more likely to request time off, and frankly, they're not being productive. Again, it's very important to have a drug screening policy in place, just like you have a background screening policy in place, stating who is subjected to drug tests, when they would be drug tested, who would manage the process. So just like a background screening policy, if you're going to be implementing drug testing, please make sure you have a drug screening policy in place. What's the permissible purpose for employers to drug screen? Pre-employment. Again, ensure your drug screening policy states that drug testing will be done on all applicants pre-hire to determine suitability with the company. Post-accident. Anytime an accident's done, usually over a certain dollar amount, it's good to drug test the person, and time is of the essence, so you want to make sure you're getting them into the lab or analyzing their urine ASAP to ensure that you're not, losing control or they try to wash out or flush out their system. Retest. Usually we get positive tests. A lot of employers like to retest the person, give them a second chance. A lot of the times we get a negative dilute test, and a negative dilute test is that there was too much water in the urine to give an accurate reading. That could have been done intentionally or unintentionally. Maybe they tried to flush out their system, or maybe they're taking prescription drugs that kind of masks the drug, masks a negative dilute test. We recommend employers to retest any individual that has been tested as a negative dilute. If your drug screening policy considers a negative dilute a positive test, then it is what it is, and the person can no longer be considered for employment. The negative dilute test, or even tests that the temperature is out of range, what that means is the urine that was collected, the temperature of the urine is not in the range where it should be and can't be tested. Therefore, it would be denied. In both of those cases, you would want to retest the individual. Random tests. This would be mainly for Department of Transportation companies that are regulated by the Department of Transportation, trucking companies, or any company. If you implement a random drug screening program, make sure it's in your drug screening policy. Make sure that it is random. You're not targeting the same person. But that is another permissible purpose that employers can use drug tests for, as a random test. There are different types of tests. We do offer a 5, 7, 9, or 10 panel test. And that's testing for 5 different types of drugs, 7 different types of drugs, and so on and so forth. Obviously, we recommend doing the 10 panel test, as it is the most comprehensive. However, speaking back to Department of Transportation companies or contractors will specifically state 9 panel tests must be done, 7 panel tests must be done, or 5 panel tests. But we are able to do those 4 different types of panel tests. Different types of specimen. The most common is urine. They go to the lab and submit the sample. The lab analyzes it and reports the results to us. Or we also have clients that like to do hair follicle testing. And this is done in the lab as well. We provide them with the kit that they would need to take to the lab to get the hair sample and send it off to the lab, and then we get the results as well. Good thing about the hair follicle test is the detection time is much longer than the urine test. Hair follicle testing, we could search up to 3 months after they intake the drug to see if it's a positive. And of course, the detection time does depend on the frequency of use. And it specifically states that here. But a lot of our clients like to do urine. It's a lot more cost effective. However, hair follicle testing is a little bit more, but you're doing all that you can in ensuring that the person hasn't taken any drugs within the last 3 months at least. Forms of drug tests available to employers. We do have an on-site solution where we provide our clients with all of the materials, test cups, test strips that they need to administer the test themselves. They could get instant results right then. Of course, any positive test, they could just ship the sample off to the lab that we had found for them so that it could be reviewed by a medical review officer to ensure that it is a positive test. A lot of our clients don't like to handle urine, which is totally understandable, but we do have that solution in place. Lab-based testing, this is the most common. We find a lab either closest to our client's physical location or closest to the applicant's home address. We have thousands upon thousands of labs at our disposal. We send our client an electronic chain of custody form via email, so they place the order on our platform. We email them a PDF chain of custody form, and they go right to the lab that's on the form. And that's the majority of how our tests are done is lab-based. Any and all positive or negative dilute test is reviewed by a medical doctor, and the results are reported to us. We also have an instant lab-based product where it's in selected labs that the applicant can go and submit the urine, and right there at the lab, it's put through what is called an e-reader, and the results are given to us within 20 minutes of submitting the sample. And this is a very, very good solution, especially if you want to make sure that you're getting the results in the most timely manner. Almost instant with regards to getting the results, but you're not handling the urine, you're just sending them off to a lab. Pros and cons of social media, and this is a very, very hot button issue right now. You may have read a lot of case law relating to employers utilizing Facebook or using LinkedIn or using Twitter to kind of make their own employment decisions. And we did a webinar back in December specifically speaking to social media searches. So I encourage all of you to visit our website and pull that from our archived library. Pros for conducting social media searches. It's a good recruiting tool. LinkedIn is a very, very good resource for hiring managers to go on and search for individuals that they could potentially bring on with regards to their experience, their education, kind of who they know. So it's really, really good for a recruiting tool. Social networking. It's good to network socially. Putting events up or things that the company is going to be doing or the individual is going to be doing. Special invites, anniversaries, birthdays, graduations, just communicating to your friends that events are coming up. And it's an informal form of communication. So these are all reasons why I think social media was done in its inception, but now it's kind of gone in a different direction. The cons for conducting social media searches. And this would be cons for employers utilizing social media to make employment decisions. Maximum possible accuracy. Like we had mentioned earlier, the FCRA states that background screening reports must adhere to the maximum possible accuracy possible. I know that kind of is redundant, but we need to ensure that the report that we're providing to our employer does in fact belong to the subject of the report. Fact of the matter is, with social media, there is not a fingerprint, there is not anything that identifies that that social media profile belongs to the applicant that you're bringing on. There's no way of identifying that. Identity theft is huge, and there would not stop anyone from opening up a Facebook profile on someone they don't like, on someone that they may be going after the same job, and put all of this derogatory negative information on there, deceiving the employer to think that, yes, this Facebook profile belongs to your applicant, and look at all this information that they're putting out there. So it's really, really important to realize, does this Facebook account or does this Twitter account really belong to the applicant that you have in front of you? There's no pre-adverse or adverse action process. HR managers are just going on Google, finding out these people's Facebook, finding out blogs, looking at comments that they posted, and just making an employment decision there, and not giving the applicant the opportunity to dispute the information that they found. That goes hand in hand with the disclosure and authorization form. There's no formal signed release form given to the employer to go ahead and do these social media searches. They're just going ahead and doing it on their own, and that's, of course, violating the FCRA. More importantly, employers could be potentially discriminating against protected classes. So if they find out that, if they're doing a Facebook search and they find out the individual's date of birth, or find out that he's a little bit older or she's a little bit older, or let's say they find out that this person, is alternate lifestyle, let's say the person is handicapped, or for whatever reason the person has a religious affiliation that the company really doesn't like, has a political affiliation that the company doesn't, you're discriminating against them based on protected classes, disability, being gay, lesbian, religious affiliations, things like that. So that could open up a company's liability greatly. And again, the FCRA is not FCRA compliant. If you are going to be using social media as a screening tool, make sure you have a social media policy in place. Specifically saying that Facebook or social media will not be allowed during business hours, especially with the personal one. Obviously, if a business has one, then that would be allowed. But it's really important, especially the way things are going. I don't see social media slowing down at all to have a background or having a social media policy in place. And recently, certain states have banned employers from requiring job applicants to divulge their social media login. A lot of the times, these Facebook have their own privacy settings where you have to befriend somebody in order for them to see your profile. Employers are just asking for their login information directly to gain access, or they're kind of deceiving the employee in that, hey, you have to befriend our company as part of the onboarding process. Therefore, they are granted permission to view the Facebook profile, and they have everything that they want. So it's sad that state law has to come out banning employers from asking applicants for their login information, but Maryland is kind of one of the first ones, and I have a feeling a lot of other states will follow suit. Okay, a pre-adverse versus adverse action process, and this is where a lot of employers are falling short and are getting in trouble because of this. If an employer decides to take adverse action in whole or in part of information contained in the consumer report, the employer must take the following actions. So you get a background report, there's information on there that, that you feel would be a detriment to your company, you don't want to bring the person on for whatever reason, you have to ensure that you're completing the pre-adverse adverse action process, and it's a two-step process. There's two letters, the pre-adverse action letter and the adverse action letter. We provide both of these letters to our clients. They obviously brand it with their company information. And the letter just specifically states, Employer's Choice Online conducted a background check on you, reported some derogatory or negative information. Here's the background check. Here's a copy of the FCRA Summary of Rights. You have the opportunity to contact the background screening company to discuss the background. Not every applicant contacts us. Fact of the matter is, I'd probably say in 96% of the cases they don't contact us. Reason being is that all the information we reported on the background is public record. We didn't manipulate anything. We didn't investigate anything. We didn't put our own spin on it. All the information we report on our background checks is public record information. But the applicant has the right to dispute that information. And in some cases, a reinvestigation must be done because the information was wrong. Let's say for a court case, the researcher missed a document in that the case was dismissed. What we would do is have the court researcher go back to the courthouse and actually physically locate that document. If in fact it states that the crime was dismissed, we'll go ahead and append the report and let the client know. If we received inaccurate information from a university, it's the university's responsibility to change their records so that this doesn't happen in the future. But it's very important to do the pre-adverse action process. Once an employer complies with the above steps, taking the pre-adverse action, they must give the applicant employee at least 5 business days to respond. We'll always let our clients know if their applicants have contacted us to discuss their background. After 5 business days, an adverse action letter is provided, again along with the report and the FCRA Summary of Rights stating they'll no longer be considered for employment. It's very, very important that employers are doing this. Like I said, a lot of employees have been taken to court for not doing the pre-adverse adverse action process and have had to pay a very, very hefty penalty for that. So your background screening company should be providing you or providing guidance on the pre-adverse adverse action process. So please make sure you're doing this if and only if you're going to be making an employment decision based on a background check. Other considerations. More than half of disclosure forms used by employers violate the law. The most common violation is a form which includes a waiver by the consumer of his or her rights. The form will consist solely of the disclosure that a consumer report may be obtained for employment purposes. You don't want your disclosure to state that they're waiving their rights completely, or they're completely holding the company, the employer, the background screening company harmless for any wrongdoing. It just needs to solely disclose that a consumer report is being obtained for employment purposes only. Very, very important. Steps that employers could take immediately to prevent a bad hire. So let's say you're thinking about doing employment background checks, you're kind of on the fence and you kind of want to stop the bleeding before you have a solution in place. Placing those signs is very, very important. You want to make sure you're placing those signs in a lobby, in an area where the candidate is completing the application, and just deterring those individuals who are hiding something. Placing notices on your website, on your careers tab. Let's say you have an online application. It's good and really important to put, a little note on your online application that the company conducts background checks. When posting a new position available, put down background checks are required. So if you're using a job board, if you're using Craigslist, if you're using Monster or Career Builder, put on there that background checks will be conducted on any applicant that wants to process with your company. If you are utilizing a temp agency, ensure that they're doing background checks on the temps they're sending to you. If not, it'd be a good idea for you to do it, especially if you're going to be bringing on the person as a regular full-time employee. You are allowed to do a background check on them again. So if you are utilizing a temp agency, please make sure that they are doing backgrounds on the employees and doing good backgrounds. They're not just doing that nationwide database search, but see what their background screening process is And if it's up to standards, great. If not, then maybe that's something that you want to take on. And that concludes the presentation. Unless anyone has any questions at all, please be, you're more than welcome to email me any kind of questions at all. You all have my email address. I'll get back to you. If there's any clarification that you need, if there's any further topics that you'd like to see done, please don't hesitate to reach out to me. This webinar will be uploaded to our website approximately a week after today's date, just like all of our other webinars. So if you missed anything, not a problem. You could definitely access our website and go to our archive webinar section and view this webinar. But I really want to thank everybody that joined us today. We like to do these quarterly, so we will be hosting one very shortly. And I encourage you again to reach out to me with any topics that you would be interested in and share this with anyone. So again, please email me any kind of questions that you may have. I'm looking at the chat feature right now, and I don't see any questions as of yet. So please email me. And what I could do is provide a response and maybe share it with the whole group in case you kind of had the same kind of questions. So again, I appreciate everyone attending. I know that you all have busy schedules. Thanks again, and look forward to seeing you on the next webinar. Thank you.